This is an expose of the weaponization of law by Kenya's DCI. This is a constitutional breakdown. In the focus case is the Rose Njeri Tanguras versus Kenya's government. This is the charge sheet. The charge sheet reads that it's an unauthorized interference with the computer systems, of which in reality, a potentially unconstitutional arrest and a worrying abuse of cybercrime laws. First violation is violation of Article 49, where the rights of arrested persons says in Article 49, subsection 1, which says an arrested person has the right to be brought before a court as soon as reasonably possible and not later than 24 hours after being arrested. See what happened. Rose Njeri was arrested on 30th May 2025. She was then taken to court on 3rd June 2025, violating the 24-hour rule. No justification for delay, like a weekend or public holiday, has been stated. Look at that. This detention is unconstitutional, and any evidence gathered after this delay could be deemed inadmissible under Article 50, subsection 4, which states that evidence obtained in violation of the rights must be excluded. That's the law now. So, another abuse that happened is abuse of Section 16 of the Cybercrime Act. The law says in Section 16 of the Computer Misuse and Cybercrime, a person who causes a computer system to perform a function with an intent to secure unauthorized access, impair the operations, or cause damage commits an offense. What's wrong with this case? Rose is accused of sending automated emails. There is no evidence that she hacked the system, damaged it, or intentionally impaired operations. Bulk emailing a government address could be civil disobedience, but not a cybercrime. So this appears to be a criminalizing political expression, not a technical offense. Number 3, the DCI history of politically motivated cybercrime cases. The DCI has a pattern of overreach, especially under the guise of cybercrime. Examples include the arrest of the blocker Cyprian Nyakundi multiple times, which the offense was the same, and the court ruled in his favor based on the Freedom of Expression Article 33. The activist Boniface Mwangi was also arrested on the same charges on tweets, and which said that it undermined the state authority, but the court reiterated that criminal criticizing is not a crime. The DCI, so this is the pattern. The DCI frames digital dissent, emails, tweets, blogs, and cybercrime. Mass communication is rebranded as interferences, violating Articles 33 and 34. Violating Article 33 and 34 of freedom of expression and media. So another one is the faulty charge sheet, the abuse of process. The charge sheet includes numerous typos, interferences, crime, ophthalmia, charge, a red flag that the arrest may have been rushed or politically motivated. The judge may have no forensic evidence or clear intent. Past judgments like that of Ocheng on 2016 ruled that poorly framed charges can render a trial null and void. Conclusion, this charge sheet could be struck down in a constitutional petition. In lack of transparency from DCI and prosecution is another one, where the witnesses listed as empty, and this indicate manufactured or incomplete evidence. The police often add witness names retroactively, which violates fair trial guarantees under Article 50, subsection 2J, to be informed in advance of the evidence of prosecution intends to rely on. The final verdict is a short trial, not justice. Rose Njeri case is a mirror of state paranoia, where the DCI, instead of investigating crimes, prosecutes digital dissent. Parliament email servers are treated like sacred cows, yet public communication portals. They are in the public domain. Citizens, especially tech-savvy youths, are criminalized for using technology in civil spaces. So my call to action would be, Kenya needs to amend the Computer Misuse Act to prevent it from being used against free speech, and audit DCI conduct to prevent illegal detention, because these detentions has become too much for now. And politically driven prosecution should never happen in a nation like this. So the civil societies also need to defend the constitution freedoms in the digital age.